here, please. On the record, in the matter of the people of the state of Michigan, just people of the city of Lansing, it looks like, versus Tatiana Ruiz. What's your name here? Okay. And this is file number 21-00009 20L2599174 and then 21-00009. I have here, it looks like a driving while license is suspended. Looks like you were originally arraigned on this back in 2021, and then you failed to appear at the time it was assigned to Judge Alderson. And it's now reassigned to Judge Flores because she has since retired. And so this is a driving while license suspended citation that you allegedly received back on December 27th, 2020 at approximately 8:09 p.m. at the area upon Jolly Road, Addermill, Pleasant Grove, City of Lansing, Ingham County, State of Michigan. Allegations are that you did operate a motor vehicle while your license was either suspended, revoked, or denied. So you have the right to proceed to a trial in this matter. You have the right to a jury trial. You have the right to be represented by an attorney at that trial. If you can't afford to hire an attorney, you can make a request to have a public defender appointed to represent you at the expense of the public. You understand your right to counsel and your right to trial? Okay, I think previously it was noted that you did not request the public defense office to represent you. Did you want to make a request to have them represent you? Okay. Okay, you have the right again to proceed to trial and a jury trial and have the city prove each element of the charge of driving while license suspended beyond a reasonable doubt. It is a misdemeanor. Maximum penalty is 90 days in jail and or $500 in fines. Okay. Okay, and then here I will enter a plea of not guilty on your behalf. And it's scheduled for a pre-trial before Judge Flores. He's in one courtroom over, okay? But you can appear via Zoom. It's going to be March 3rd at 10:30 in the morning. We'll get you your notice to appear. And then you also had an equipment violation that you received the same date of that incident. And there, when you failed to appear back on July 25th, 2021, a default judgment was entered, and it's way too far out to have that set aside. So you owe $192 on the equipment violation. Okay, how do you intend to pay that?
I'm in the midst of trying to get another job because I'm only making $12 an hour at my job currently. And they have been cutting my hours, so I am looking for another job. I get paid by week.
Okay, how much will you pay monthly on it?
I can pay $20 a month.
When are you going to make the first payment?
This week, but next Thursday.
Okay, next Thursday is going to be the 27th. That's when you're going to do it? Okay. So you'll make payment on or before the 27th of each month, okay? How about your phone number?
Right now, my phone is currently off, so I've been using the text now number. I don't know it by heart. Is it okay if I look at it?
Are you expecting to get your phone back on at some point?
Like I said, my job has been cutting my hours.
I understand.
So I'm not.
You're not sure? Because the number we had from you is from 2021, it ended in 9118.
Yeah, I have a different number.
Okay. What's the number?
517-974-0683.
That's the text now?
No.
Okay. I'll note here that phone is currently disconnected. And you're at the Azures on Christensen?
Yes.
Okay. Bond is 100, personal recognizance. I make sure you report to all of your future court dates. If you've had your license restored, you'll bring proof of that to your next court date, okay? Okay, do you have any questions at this time?
So I am doing weekends in Eaton County. Is this, they wanted me to show proof that like either been arraigned or resolved it.
Yeah, when you bring that, that's proof that you've resolved it because you have a next court date now.
Okay, okay, thank you.
You're welcome. You're all set.
Okay, thank you.
You're welcome.
For that one.
Can you hear me in the jail?
Yes, we can, Your Honor. We just can't see you.
Really? I don't know why. Mr. Lee, can you see me?
I can see you, but my video indicates that you cannot see me.
We cannot see you, Mr. Lee.
Even when
I don't know why the jail can't see us. We can see you in the jail. And then the other party can see us. I don't know what's going on with, I have no clue what's going on here.
I can see the jail and I can see you. I don't know why my video doesn't seem to be working. It was working fine this morning.
Okay, and the jail still can't see us. There's no way for you to adjust your speed in the jail?
No, there's not, Your Honor.
Okay, let me remove you and then have you log back in.
Okay.
Must be a technical issue going on. Let's see.
It's cold.
That's valid. Did it work now?
Yes, it did, Your Honor.
Okay, sounds good. On the record in the matter of the people of the state of Michigan versus Zachary Wy, 25-005222 FY, counsel appearance.
Good afternoon, Your Honor. Takura Nyamfuku's on behalf of Mr. Whaley, who I see now on the screens.
Okay, Mr. Whaley, you can hear us in the jail, correct?
I can, Your Honor.
Okay, today was the date scheduled for arraignment. I do have a felony complaint here, and the allegations set forth allege that on or about January 23rd, 2025, at or near the area of 1804 Drexel Road in the city of Lansing, Ingham County, state of Michigan, that you did allegedly commit the act in count 1 of child sexually abusive activity, and that on or about that date and time at that address that you did attempt, prepare, or conspire to, or did arrange to produce, make, copy, reproduce, finance any child sexually abusive activity and or material, and that this is contrary to Michigan Compile Law 750.145 C2A. Count 1 is a felony. The maximum penalty is 20 years in prison and or $100,000 in fines. Count 2, computers, internet, communicating with another to commit a crime, maximum imprisonment of 15 years or more, or life. Alleging that on or about January 23rd, 2025, at the address of 1804 Drexel Road, that you did allegedly use the internet to communicate with a EG for the purposes of committing child sexually abusive activity where the victim or intended victim, that being someone by the initials EG, was 13 years old, was a minor, and this was contrary to Michigan Compile Law 750.145 D2F. There's a Sex Offender Registration Act notice. It states here, this is a tier 2 offense under the Sex Offender Registration Act if the underlying offense is in violation of MCL 750.145C. It says it's a tier 3 offense if the defendant has a prior conviction for a tier 2 offense. Count 2 is a felony. The maximum penalty is 20 years and or $20,000 in fines and reimbursement to the government for expenses incurred in relation to the violation in a manner indicated by MCL 769.1F. And a consecutive sentence may be imposed for a conviction on the underlying offense. Count 3 is children accosting for moral purposes, alleges that on or about January 23rd, 2025 at 1804 Drexel Road, that you did accost, entice, solicit, or a child less than 16 years of age with the intent to induce or force that child to commit an immoral act, to submit to an act of sexual intercourse or an act of gross indecency or other act of depravity or delinquency, or did encourage the child to engage in one of these acts contrary to MCL 750.145A. There's a Sex Offender Registration Act notice as applied to count 3, stating this is a tier 2 offense under the Sex Offender Registration Act, and it's a tier 3 offense if the defendant has a prior conviction for a tier 2 offense. There's a HIV STD testing notice saying take notice that pursuant to MCL 333.5129, upon bind over to the circuit court or recorder's court, the district judge shall order the defendant to be tested for venereal disease, hepatitis B infection, and for the presence of HIV or an antibody to HIV if the judge determines there is reason to believe the violation involves sexual penetration or exposure to a bodily fluid of the defendant. If the district judge determines that testing is not required upon conviction, the court must order the defendant to be tested. Count 3 is a felony, 4 years and or $4,000 in fines. Count 4, computers, internet communicating with another to commit a crime, maximum imprisonment of 4 years or more, but less than 10 years. Alleges that on or about January 23rd, 2025, at the area of 1804 Drexel Road, Lansing, Michigan, that you did use the internet to communicate with EG for the purpose of communicating or committing, that is, accosting a minor for immoral purposes, contrary to MCL 750.145D2D. Again, Sex Offender Registration Act notice is applied, stating this is a tier 2 offense under the Sex Offender Registration Act if the underlying offense is a violation for MCL 750.145 or 750.520G. It is a tier 3 offense if the defendant has a prior conviction for a tier 2 offense. Count 4 is a felony, maximum penalty 10 years in prison and or $5,000 in fines, reimbursement to the government for expenses incurred in relation to the violation and manner indicated by MCL 769.1F, and consecutive sentence may be imposed for a conviction on underlying offenses. Do you understand each of the charges read in those counts and the maximum penalty that's attached to each, sir?
I do, Your Honor.
You're represented by counsel. It looks like you've retained Chartier and Nine-Fukusa for this matter. You have the right to counsel and you have the right to be represented by an attorney at each stage of the criminal prosecution, and the right to be represented by an attorney if you're questioned by law enforcement. If for some reason you are not able to continue the retention and you want to have appointed counsel, you would have to undergo an intake to see if you're eligible to be represented by the public defender's office. But you do have the right to have counsel even if you can't afford one. Do you understand that?
I do, Your Honor.
Okay, you have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. You have the right in this matter to proceed to a preliminary examination within 21 days of today's date, unless you waive that 21-day timeline or the court finds good cause to go beyond the 21-day timeline. At the time of your preliminary examination, you have the right to require the prosecution meet their burden of establishing that they have sufficient probable cause, that the felonies that you've been charged with were committed, and sufficient probable cause to charge you as the person who committed those felonies. You're currently scheduled for probable cause conference before Judge Michael Flores. It's going to be scheduled Thursday, February 27th at 9:30 in the morning. You have a preliminary examination before Judge Flores. It's currently scheduled for Thursday, March 6th at 9:30 in the morning. You should have received a notice to appear for those dates. Is that accurate?
I have, Your Honor.
Okay, do you have any questions so far?
No.
You have the right to continue to trial and you have the right to jury trial. You have the right to be presumed innocent until proven guilty. You have the right to require the prosecution prove your guilt at trial by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent at any trial and not have silence be used against you. You can waive your silence at trial and testify on your own behalf if you like. You have the right to see, hear, or question in court any of your accusers or any witnesses called to testify against you. And you have the right to have witnesses subpoenaed to testify on your behalf. Do you have any questions about those rights?
I do not, Your Honor.
Court will enter a plea of not guilty on your behalf. Are you currently employed?
I am
Where?
at a nonprofit called Safe and Just Michigan.
You said called what?
Safe and Just Michigan.
And your address is current at the Drexel Road?
That's correct.
And what's your phone number?
517-285-7379.
You can address bond counsel.
Thank you, Your Honor. I know I don't need to educate the court about the fact that while the charges in this matter are serious, certainly we're not dealing with the type for which a bond may be denied. Mr. Whaley has extensive ties to the community. He resides in Ingham County and has been almost a lifelong resident. And I think, as evinced by my very presence here, this is something that he certainly will be present for, will be here for every court date. And I know that in addition to working in Ingham County, owning a home, to the best of my knowledge, I think his CCH probably is comprised of nothing more than a couple of speeding tickets. And but I know, again, the court certainly has access to more information than we normally do, but I'm not aware of an extensive record. So with regard to flight, I don't think that is a concern that the court should have at the forefront of its mind. Now, with regard to the nature of the charges, I think I would not be surprised, and I've actually conversed with Mr. Whaley about the probability that conditions of some sort relating to limited use of internet may be imposed. I would ask, though, just based on what he's not charged with, given his extensive ties, his employment history, that if the court is not inclined to grant a personal recognizance bond, that perhaps a 10% bond of some amount be ordered. Thank you.
I don't have any prior criminal history noted here for the defendant, and I've not received a bond report indicating any risks of flight or prior failures to appear more than 2 times. So I'm assuming he was not interviewed by pretrial services. If he was, they've not provided a report. Outside of that, let's see here. I do note substantial ties to the community. I'm just gonna check my email, make sure they didn't email me. Okay, no, I've not received the bond report. Bond will be set in the amount of 10,000 personal recognizance with the following conditions. First, there's a no contact order in place for the protection of the victim, which the court is only been advised of their initials, that being EG. The court's also going to impose a no contact order for the defendant not to be in contact with or to have to be in the presence of minors. I don't know if the defendant has children.
He does not know.
Okay. Otherwise, I would have ordered supervision, but that's not necessary at this time. Also, while out on bond, you have the following conditions. You're not to use, purchase, or possess a firearm or dangerous weapon. You're not to travel outside the state without prior approval of the court. You're not to use drugs or alcohol unless you have a valid prescription. You need to report to pretrial services within 48 hours of your release. I am going to order GPS tether. Do you have any questions about your bond conditions?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing additional. Thank you for your time, Your Honor.
You're all set, sir.
Thank you.
On the record in the matter of the people of the state of Michigan versus Paula Randall. I have here 22-01593.
All of those attempts.
I also have 22-01594, counsel appearance.
Assistant Public Defender John Lee appearing on behalf of Paula Jane Randall.
Okay, Ms. Randall, let's start with file number ending 593. I do have a misdemeanor complaint here that alleges that on or about April 10th, 2022 at the area of 6200 South Pennsylvania Avenue, City of Lansing, Ingham County, State of Michigan, that you did allegedly commit the act in count 1 of retail fraud in the 3rd degree, and that you did, while Myra was open to the public, steal property of the store that was offered for sale at a price less than $200, contrary to MCL 750.356 D4. Count 1's a misdemeanor. The maximum penalty is 93 days in jail and or $500 in fines, or 3 times the value or difference in price of the property stolen, obtained, or attempted to be obtained, whichever is greater. File number 594. I also have a retail fraud 3rd degree, also at 6200 South Pennsylvania Avenue, for the date alleged to have occurred back on April 7th, 2022. Again, alleging that while Myra was open to the public, the defendant did steal property of the store that was offered for a sale at a price of less than $200. Again, a misdemeanor, maximum penalty 93 days and or $500 in fines, or 3 times the value or difference of the price stolen, obtained, or attempted to be obtained. Do you understand the charges read in both files and the maximum penalty?
Yes, I do, Your Honor.
You have the right to counsel. Mr. Lee from the Public Defender's Office is representing you today for the purposes of your arraignment, but you have the right to have an attorney represent you at each stage of the criminal prosecution, and the right to be represented by counsel if you are questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the Public Defender's Office represent you at the expense of the public. You understand that, right?
Yes, ma'am.
She's requesting court-appointed counsel, Mr. Lee.
Yes, she has, Your Honor.
Okay, Ms. Randall, you have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty or you can stand mute. But if you stand mute, the matter will continue all the way to a jury trial. And you have the right to jury trial. You have the right to the presumption of innocence. You're innocent until proven guilty, and you have the right to require that the prosecution prove your guilt by proving each element of the charges being brought against you beyond a reasonable doubt. You can remain silent at trial and not have silence be used against you. You can subpoena witnesses to testify on your behalf at trial. You have the right to see, hear, or question in court any of the witnesses that the prosecution intends to call against you. And you can also waive your silence and testify at your own trial. Do you understand those rights?
Yes, ma'am.
The court's going to enter a plea of not guilty on your behalf at this time. Are you currently employed?
No, ma'am. I lost my in-home care patient of 14 years last year.
What's your home address?
I have a mailing address,
What's that?
2224 Pamela Place, in East Lansing, Michigan, 48911.
Repeat that.
2224 Pamela Place, Lansing, Michigan, 48911.
Who lives there?
It's a gentleman I do housekeeping for.
Where do you live?
I'm in between places right now.
What's your phone number?
I have an emergency phone number, which is my fiance's, Alan Collins, 517-614-4445.
You are currently scheduled for a pre-trial conference before me, Judge Simmons. Your pre-trial on file number ending in 594 is March 24th, 10 o'clock in the morning. And the other file, same time, March 24th, 10 o'clock in the morning. Are you currently on probation or on parole?
Oh, ma'am.
Have you ever missed court in the past?
Only for, I got supposedly I had received a notice of failure to appear for another case, but I never received anything for that. That was for the court costs and fines for the assault and battery from back in 2000. That's the only one I know of.
You can address bond.
Thank you, Your Honor. We would ask the court to consider that Ms. Randall has lived here in the Lansing area since she was approximately 3 years old. She is engaged and intends to continue to reside here in the Lansing area. She reports that her only prior criminal offense was an assault and battery that she was just talking about in the year 2000, which is fairly dated. And based on that, we would ask the court to consider a personal recognizance bond on her behalf.
You mean the assault and battery from 2008?
If
You're talking about?
you would have
It might
better
have been from
record
the-
than I would, Your Honor. Like I say, 2000 is what she reported to me, but 2008 was probably more accurate.
Yeah, but she should remember it because it's in collections. Let's see
Agreed.
here, she has a collection here, she owes over $2,100 on this collection matter.
Okay. I can make a payment on that tomorrow afternoon of
Okay, so
$40.
Okay, give me just a moment. This
Yes,
is from 2008. Looks like there was assault and battery. She pled no contest to.
I also did 25 days for that.
That's why I'm reviewing the file. Well, you did 25 days after the judge had to terminate your probation because you failed to comply. Then there's a 2013 file of identity theft. That probation was also terminated. So failure to comply. So that explains why the collections is as high. It's more than one file. So you owe $2,101. You were supposed to be on a payment plan, but you've not made a payment, it looks like, since 2013. When are you gonna pay this?
I can pay a payment tomorrow afternoon for sure.
How much?
Of $40 is the most I can do. And then again, another payment on Sunday.
Are you employed? You say you're not employed.
No, ma'am, I donate twice a week.
Okay, so you're donating what, blood, plasma? What are you donating?
Plasma.
You're gonna make payments off the money that you're donating, getting
Yes,
from
ma'am.
donating?
Yes, ma'am.
But you don't
Every
have a
week.
house, you say, you don't have a working phone. Let's see, and then did you turn yourself in on these warrants, or were you picked up on something?
No, I was picked up at my fiance's building because we were going to be sleeping in the hallway, and a neighbor had called and made a complaint.
You can address Bond any further, counsel.
Thank you, Your Honor. In light of the recently shared information, we would ask the court to consider that she's definitely not a flight risk. She is working to survive right now, lost her full-time employment job and is looking for another one. And we just asked the court to consider that in setting bond.
I don't know that she'll be leaving the state of Michigan, and if that's what you mean, flight risk, but not returning to court is also considered flight. And if you know you got outstanding obligations and or pending actions, which these matters have been pending since 2022, and I have reason to believe she was aware of that. I don't know why she lost her employment a year ago, but I don't know how you're looking for a job and you don't know you have warrants.
Ma'am, I just lost my in-home care patient of 14 years last February. I donate twice a week. I am able to.
I understand that, but you lost your job a year ago?
Yes, I just recently lost my job.
Well, this is February, so it can't be last February and that's considered recent. Last February was a year ago.
Yes, I know that. He's been gone a year as of February 5th of this year.
Okay, so then that's not, you didn't lose your job last year and it's recent. If this was a year ago, what have you done in the last year to find work?
I did 14 years of in-home care service up until last year.
What have you done? I didn't ask you
Excuse
that.
me.
What have you done in the last year to find a job?
I just recently lost my job. That's what I'm saying. I have not been able to go out and look for a job right now due to not having an address to use. I had a mailing address. I cannot use that mailing address because the gentleman's been sending my mail back. So I didn't know anything about the court hearings or anything from 2022 at all.
That's not what I asked. That's not what I'm asking you, because now you're telling me that you can't get a job. You can't get a job because you don't have an address.
It's not that I can't get a job. I have not been able to go out to look for one due to I have walking pneumonia. I just found out I have walking pneumonia. I have not been able to go out to look for a job, another job, because I'm in the process of getting my new documents like my ID, my social security card, my birth certificate. Due to moving, I've lost all that information, Your Honor.
Right, but this has been a year that you say you lost your job. What have you done in that last year to be in the process of doing those things?
Going through all the agencies that I can to get the information that I'm needing so I can look for a place.
Which agencies? Which agencies?
DHS, my former worker at the admin house. I'm trying to get in contact with her to get my documentation that she has on file so I can find another job and find another place to live at. Me and my fiance are also in the process of trying to find something for us to move to because we can no longer be at his aunt's house.
Who was your contact at admin house? What's their name?
Ty. I do not know her last name.
Ty?
Yes, ma'am.
How are you been trying to get in contact with Ty?
I've been calling the admin house to get her number. They have not been able to leave it to me yet. They have not spoke to her yet. I do have her information somewhere in some of my belongings that's still at my fiance's aunt's apartment. I was residing with my.
If I told you that Ty has not worked at admin house in over a year, would that surprise you?
No, it will not.
But why, if you contacted admin house, why wouldn't they have told you that?
They have told me that she doesn't work there. She works from home. They do have her cell number, but they have to locate the cell number.
Okay. A bond in file number 1593 is set in the amount of 200 cash surety. A bond in file number ended in 594 also set in the amount of 200 cash surety. While out on bond, you have the following conditions. You must report to all of your future court dates. You are not to use, purchase, or possess drugs or alcohol without a valid prescription. You're not to possess a firearm, ammunition, or weapon of any kind. You're not to travel outside the state without prior approval of the court, and you're not to be at the area of 6200 South Pennsylvania. That's bond conditions on both files, okay?
Yes, ma'am.
Okay, and then we'll have the matter for your collections set out for a show cause on the date of your pretrial so that we can address that at that time, okay?
All right.
You do need to get back on a payment plan, but I don't think that you need to donate plasma to do that. I think you need to get a job to do that. So we'll address that at another time.
But I can, like I said, I will make a payment tomorrow for sure.
Okay, any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
You're all set, sir. Ma'am. Let's see, on the record in the matter of the people of the state of Michigan, this is versus Harvey Edwards III, 23-05-02597.
Your Honor, Harvey Edwards isn't in here right now.
Why not?
He is in his cell because we are communicating with the prosecutor's office against other fresh charges right now.
Okay, so he's not going to be arraigned today?
Correct.
On this matter, okay. On the record in the matter of the people of the state of Michigan versus Angela Bates, 25-00145. Counsel appearance. Mr. Lee, are you there?
I'm sorry, Your Honor. Yes, Assistant Public Defender John Lee appearing on behalf of Angela Bates.
Okay, Ms. Bates, I have a misdemeanor complaint here that alleges that on or about October 29th, 2023, at the area of 625 West Madison Street, that's in the city of Lansing, Ingham County, state of Michigan, that you allegedly committed the act of stalking and that you did engage in a willful course of conduct involving repeated or continuous harassment of a Shariva Martika Adams, the conduct being such that will cause a reasonable person to feel terrorized or frightened or intimidated or threatened or harassed or molested. And such conduct did cause Shariva Martika Adams to feel terrorized, frightened, intimidated, threatened, or harassed or molested. And that this was contrary to Michigan Compile Law 750.1441H2A. That's a misdemeanor with a maximum penalty of 1 year in jail and or $1,000 in fines or up to 5 years of probation. You understand the charge and the maximum penalty associated with the charge.
Yes, yes.
You have the right to be represented by counsel. Mr. Lee from the Public Defender's Office is representing you for your arraignment only. You have the right to be represented by an attorney at all of your court appearances and if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the Public Defender's Office represent you at the expense of the public. Do you understand your right to counsel? Do you understand your right to counsel, ma'am?
Yes.
Okay, you have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You in this matter can plead guilty, you can plead not guilty, or you can stand mute. If you stand mute, the matter will continue all the way to a jury trial. You have the right to a trial and you have the right to the presumption of innocence at your trial. So that means you're innocent until proven guilty, and you have the right to require that the prosecutor prove each element of the charge of stalking beyond a reasonable doubt before you are considered to be guilty. You can remain silent by right at your trial and not have that silence be used to prove or imply that you're guilty. You have the right to waive silence at trial and testify on your own behalf if you like. You have the right to see, hear, or question any of the witnesses that are called to testify against you at trial, and you have the right to have witnesses subpoenaed to testify for you at your trial. Do you understand that?
Yes.
Is she requesting court-appointed counsel?
Yes, she has, Your Honor.
The court will enter a plea of not guilty on your behalf. Are you currently employed, ma'am?
Yes.
Where?
Room services.
What do you do
I
there?
drive school buses in Ann Arbor.
Are you on probation or on parole?
No.
What's your home address?
2962 Birch Hollow Drive. It's BIRCH Hollow Drive, apartment 1A, Ann Arbor, Michigan, 48108.
What's your phone number?
734-469-8672.
You're currently scheduled for pretrial before Judge Buchanan. It's going to be March 24th, 11 o'clock in the morning. You should have received notice to appear for that date. Is that correct?
Yes.
Have you ever missed court in the past?
No.
Mr. Lee, you can address Bond.
Thank you, Your Honor. Ms. Bates reports some limited criminal history. She had a charge that that she was responsible for that she claims was expunged from her record back in 2010, and a traffic-related misdemeanor as recently as 2022. I think she said there was one other misdemeanor charge in 2019, but nothing of a violent nature. She grew up here in Lansing, but has lived in Ann Arbor for the last 10 years. She has a job. She does take care of her child that lives with her in Ann Arbor. We would just ask the court to consider that in setting bond.
I see the conviction from 2019. And I see some other traffic related convictions, but I also see a number of other contacts with the criminal justice system that did not result ultimately into conviction, but this is a lot of interaction with the criminal justice system. This is a stalking charge alleged to have occurred in 2022. I'm sorry, 2023. So some time ago. I don't believe that there is an immediate risk to the victim or to the public welfare based on the allegation. So because of that, I will grant a personal recognizance bond. Bond is set in the amount of 500 personal recognizance. You must report to your court dates, okay, ma'am?
Yes.
Okay. And your next court date, which is a pretrial, that you can report via Zoom. Obviously, you cannot be driving while you do that. You just need to have video and be in a environment that's conducive to you holding a official court proceeding. Do you understand that?
Yes.
Okay, you're not to have contact directly or indirectly with the victim in this matter, or the alleged victim, Shariba Adams. You're not to be within 1,500 feet of wherever Shariba Adams is. Do you understand that?
Yes.
You're not to use, purchase, or possess drugs or alcohol without a valid prescription. You're not to possess a firearm, ammunition, or weapon of any kind. And you're not to travel outside the state without prior approval of the court. Do you have any questions about your bond conditions? Any additional matters for the record, counsel?
Nothing further. Thank you.
You're all set, ma'am.
Thank you, Your Honor.
You're welcome. On the record, in the matter of the people of the state of Michigan versus Eric Mcclinton, 25-00071 FY. Counsel appearance.
Assistant Public Defender John Lee appearing on behalf of Eric Vondale Mcclinton.
Here, Eric Vondale Mcclinton.
Yes, ma'am. Walk up. Okay. Okay.
Okay, I have here a felony complaint that alleges that on or about August 9, 2024, at the area of 3516 Brighton Drive, which is in the city of Lansing, Ingham County, state of Michigan, that you allegedly committed the act in count 1 of attempted assault with intent to do great bodily harm, less than murder or by strangulation, that you did attempt to commit the following listed offense, and in the attempt did act towards the commission of that offense, but failed in the perpetuation or was prevented in the execution thereof, contrary to Michigan Compiled Law 750.92. That's an assault offense, but with intent to do great bodily harm, less than murder or by strangulation. The maximum penalty there, it is a felony, 5 years. It says the court shall order law enforcement to collect DNA identification profiling samples. And it alleges that you did make an assault upon a Jeanette Mcclinton by strangulation or suffocation, contrary to MCL 750.84, and that says the maximum penalty of 10 years and or $5,000. DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. I think there's an error on this. There's a count 2, domestic violence and or knowingly assaulting a pregnant individual, third offense notice, alleging that on or about August 9th, 2024 at 3516 Brighton Drive, Lansing, Michigan, that you did make an assault or assault and battery upon a Jeanette Mcclinton, a resident or former resident of your household, or an individual with whom you have a child in common, or an individual with whom you have a dating relationship, or your spouse. There's a third offense notice. It says take notice that the defendant was previously convicted of assaulting and battering his or her spouse, former spouse, an individual with whom he had a dating relationship, or an individual with whom he had a child in common, or a resident or former resident of his household, by knowingly assaulting a pregnant individual on or about says May 22nd, 2002, and by violating MCL 510813 on or about May 22nd, 2002, and therefore upon conviction will be subject to an enhanced sentence under MCL 750.815. That would enhance the sentence to 5 years, a felony of 5 years and or $5,000 in fines, and a consecutive sentence under MCL 750.506A if the assault was committed in a place of confinement. It also states that restitution may be ordered as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. There's also an habitual offender, fourth offense notice. It says take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about July 6, 2022 is what I'm assuming this is supposed to say. He was convicted of the offense of firearms possession by felon in violation of MCL 750.224F in the 30th Circuit Court for Ingham County, and that on or about August 25th, 1999, he was convicted of the offense of police officer fleeing third degree in violation of MCL 257.602A3A in the 30th Circuit for Ingham County, State of Michigan. And that on or about April 17th, 1996, he was convicted of the offense of controlled substance possession of cocaine or other narcotic less than 25 grams in violation of MCL 333.7403 to A5 in the 30th Circuit for Ingham County. Let's see. Therefore, the defendant is subject to the penalties provided by MCL 769.12. That enhances the penalty to life if the primary offense has a penalty of 5 years or more, 15 years or less if the primary offense has a penalty under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the charges right in count 1 and count 2, as well as the third offense notice that's attached to the domestic violence charge, enhancing that charge to a felony 5 years and $5,000, and then the habitual offender fourth offense notice, which enhances your maximum penalty to life because the primary offense has a penalty of 5 years or more. Do you understand that, sir?
Yes, ma'am, I do. Thank you.
You have the right to be represented by an attorney. Mr. Lee is going to represent you today for your arraignment. You have the right to have an attorney represent you at each stage of the criminal prosecution, and you have the right to have an attorney represent you if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the public defender's office appointed at the expense of the public. Do you understand your right to counsel?
Yes, ma'am.
You have the right in this matter to proceed to a preliminary examination. You have the right to have that examination within 21 days of today's date unless you waive the timeline or the court finds good cause to go beyond the 21-day timeline. Do you understand that right?
Yes, ma'am.
At the time of your examination, you have the right to require that the prosecution establish their burden of putting forth sufficient probable cause that a felony was committed and probable cause sufficient to charge you as the person who committed the felonies. You're currently scheduled for probable cause conference before me, Judge Kristen Simmons. Your probable cause conference is going to be February 28th at 9:30 in the morning. You have a preliminary examination before me scheduled in person at the court Thursday, March 6th at 9:30 in the morning. You should have received your notice to appear for those dates and times. Is that correct?
Yes, ma'am, I do.
Okay, you have the right to proceed to a jury trial. You are innocent until proven guilty, and you have the right to require the prosecutor prove your guilt by proceeding to trial and requiring them to prove each element of the charges being brought against you beyond a reasonable doubt. You can remain silent at trial and not have that silence be used against you. You can waive your silence and take the stand at your own trial if you'd like and testify on your own behalf. You have the right to subpoena witnesses to trial that would testify for you. And you have the right to cross-examine or question in court any of the witnesses called to testify against you. Do you have any questions about those rights?
No, ma'am, I don't have any questions.
Are you currently employed?
Yes, ma'am, I am a heavy duty auto repair. I'm a mechanic. 800 West Miller, Lansing, Michigan.
Is he requesting public defense counsel to represent him?
No, Your Honor, we will be representing him for arraignment purposes only.
You intend to retain counsel, sir?
Yes, ma'am, I will attain the counsel. Yes, ma'am. I would like to attain a counselor for this, because, yes, ma'am.
Okay, so although here that the defendant is, you're declining the public defense representation outside of today's date and that you will hire an attorney to represent you. Let's see, are you on probation or parole?
No, ma'am.
What's your home address?
3516 Brighton Drive. That's where me and my wife stay at, but I know allegedly this is going on, so I was staying resigned at my mom's house at 911 East St. Joe.
What's your phone number?
My phone number is 517-326-9511.
Have you missed court in the past?
No, ma'am, I haven't never missed court dates, nothing.
You never missed nothing.
No, never missed a court day. No, ma'am.
Oh, okay. Mr. Lee, you can address the court.
Thank you, Your Honor. We understand that the court will have concern for the complaining witness, and given the client's, that is to say, Mr. Mcclinton's criminal history, would probably not be open to the idea of a personal recognizance bond. We would ask the court to consider utilizing conditions and give Mr. Mcclinton some type of chance of posting bond. He has been employed for the last 12 years at Heavy D's Auto Repair. He has also lived here in Lansing all his life at the same home address for 20 years and intends to participate in these proceedings.
Yes, ma'am.
I don't know why when I ask people if they miss court before, they think I don't know the answer. I am actually usually asking so that I can see if you're gonna tell me the truth or not. This is not time for you to respond. This is time for you to listen. I have a bond recommendation here from the Ingham County Prosecution Office. It states here that there is a concern for the protection of the public because the crime involves violence towards another person, and that the defendant has a history of violent behavior specifically towards the victim, and a history of threatening and or harassing behavior towards the victim or witnesses, and that there's an intimate partner relationship. It notes here that there is a record of non-appearance at court proceedings or flight to avoid prosecution. It states that there are other factors associated with the risk of lethality in domestic assault situations, that there's been alleged threats to kill the victim or family member, escalation of violence or risk-taking over time, acute depression, or unpredictable and violent mood swings, and that the defendant has significant criminal history and a history of domestic violence against this particular victim. The people are asking for a bond at the amount of $75,000 cash surety with GPS tether, exclusion zone, and victim notification, with other conditions to be imposed. Bond is set in the amount of $25,000 cash surety, that is with GPS tether, based on the concern about his ability to get himself to court when he's supposed to, as well as a history documented by his criminal history of interaction with the criminal justice system based on violent action and history of threats noted by the prosecutor's office to this particular victim. There's a no contact order and protection in place for the purposes of protecting the Jeanette Mcclinton. So you're not to have contact directly or indirectly with Jeanette Mcclinton. Do you understand what that means?
Yes, ma'am, I do.
Okay, so you can't have any phone calls, no video calls, no text messages, no inbox messages. You can't have anybody else make communication with her on your behalf. Do you understand that?
Yes, ma'am.
There will be GPS tether with victim notification. You're not to travel outside the state without prior approval of the court. You're not to use drugs or alcohol without a valid prescription. You're not to possess a firearm or weapon of any kind. You're not to engage in any assaultive or threatening behavior. You need to report to pretrial services within 48 hours of your release from custody. You're not to be at the address of 3516 Brighton Drive in Lansing. Do you have any questions about your bond conditions?
What's my bond, ma'am?
25,000 cash surety.
25,000?
Cash surety, correct.
So that means I have had 25,000 cash?
Or you can get a bondsman.
25,000 cash here with bondsman?
We'll explain it to you.
We'll
explain.
explain.
Okay, okay, thank you.
Yep. Do you have any other questions?
No, ma'am.
Okay, any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
You're all set. Thank you. On the record in the matter of the people of the state of Michigan versus Joshua Allen, 21-01781. Appearance, please.
Assistant Public Defender John Lee appearing on behalf of Joshua D'Angelo Allen.
Okay, Mr. Allen, I have a felony complaint here that alleges that on or about February 2nd, 2021, in the area of 2210 Pollard, City of Lansing, Ingham County, State of Michigan, that you allegedly committed the act in count 1 of financial transaction device, stealing, retaining without consent, and that you did knowingly retain or knowingly possess or knowingly secrete or knowingly use a financial transaction device without the consent of a Gwendolyn Philpott Brunson, the device owner, contrary to MCL 750.157N1. That's a felony. Maximum penalty is 4 years and or $5,000 in fines. You understand the charge and the maximum penalty, sir?
Yes, ma'am.
Okay, you have the right to be represented by counsel, and Mr. Lee is going to represent you today for this arraignment, but you do have the right to have an attorney represent you throughout the pendency of this matter, and if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the public defender office appointed to represent you at the expense of the public. Do you understand your right to counsel, sir?
Yes, ma'am.
You have the right to remain silent. Anything you say, anything you put in writing can be used against you. You can plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue all the way through to a trial. You are being charged with a felony in this matter, so you have the right to a preliminary examination within 21 days of today's date, unless you waive the timeline or the court finds good cause to go beyond the statutory timeline. You're currently scheduled for probable cause conference before Judge Stacia Buchanan Friday, February 28th at 8:30 in the morning. You have a preliminary examination scheduled before Judge Buchanan Thursday, March 6th at 1:30 in the morning. You must appear in person for your preliminary examination. Did you get your notice to appear for those dates and times?
Yes, ma'am.
Is he requesting court appointed counsel?
Yes, he is, Your Honor.
You have the right to plead guilty, plead not guilty, or stand mute. The court is going to enter a not guilty plea on your behalf at this time. You have the right to be presumed innocent until proven guilty, and you have the right to move this matter all the way through a jury trial and have this prosecution prove each element of the charge that they're bringing against you beyond a reasonable doubt. You have the right to remain silent at your trial, not have silence be used against you. You have the right to subpoena witnesses to testify for you at trial, or cross-examine any other witnesses that they intend to call to testify against you. Do you understand those rights?
Yes, Your Honor.
Are you currently on probation or on parole?
I'm having started. I'm on misdemeanor probation. It's supposed to start today.
On probation out of what court?
Wayne County.
What's your home address?
3500 Blue Hill Street.
You said Blue Hill?
Apartment blue as in blue, BLUE, Blue Hill Street.
Okay.
Apartment 203.
That's in Detroit?
Yes, ma'am. 48224.
What's your phone number?
313-607-6759.
Are you employed?
Yes, ma'am.
Where?
I work at La Sienna. It's a restaurant. I'm a cook, also a dishwasher. And I also take care of my mom. She has MS.
Have you ever missed court in the past?
No, ma'am.
Until you can address bond.
Thank you, Your Honor. As Mr. Allen reports, he is working, but spends the majority of time as a caretaker for his mother. He has lived in the Metro Detroit area his whole life. He has some children down there as well. So he intends to commute from Detroit to the Lansing area to participate in the proceedings. He's been advised that he will have to do so because At the very least, his preliminary exam will require in-person attendance. He reports that he had some juvenile convictions and that as an adult, he has a conviction in 2025, just recently for attempted R&O out of Wayne County, for which he is currently on probation. We would ask the court to consider the non-violent nature of this offense in setting bond.
Okay, so it looks like you were in court this week in Wayne County, and that's
Yes.
how you likely got sit down here on this warrant, correct?
Correct, Your Honor.
And you're gonna be on probation for 18 months.
Correct.
Bond is set in the amount of $500 personal recognizance. You need to report to all of your future court dates. You understand that?
Yes, Your Honor.
Your next court date, you can appear via Zoom. You just need to make sure you have a device with a camera and that you're in an environment appropriate for court. You understand that?
Yes, Your Honor.
Okay, while on bond, you're not to travel outside the state without prior approval of the court. You're not to contact the witness directly or indirectly. You're not to possess a firearm, ammunition, or weapon of any kind. You're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess alcohol or drugs without a valid prescription, and you must report to pretrial services within 48 hours of your release from custody. You'll get that information from the jail when you're leaving, okay?
Thank you, Your Honor.
Do you have any questions at this time?
No, thank you for the time, Your Honor.
No problem. Any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
You're welcome. This is the matter of the people of the state of Michigan versus Damian Brown, 25-00520. Appearance, please.
Assistant Public Defender John Lee appearing on behalf of Damian Brown.
Damian Brown,
Ma'am.
you said you are?
Yes, ma'am.
Okay, I have a felony complaint here. And the allegations that on or about February 18th, 2025, at the area of 1406 Lyons Ave, which is in the city of Lansing, Ingham County, state of Michigan, that you allegedly committed the act in count 1 of controlled substance possession of cocaine, heroin, or other narcotic less than 25 grams, and that you did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance cocaine. And that this is contrary to MCL 333.74032AB. That's a felony. Maximum penalty is 4 years and/or $25,000 in fines. Count 2 is controlled substance, maintaining a drug house alleging that you did knowingly or intentionally keep or maintain a dwelling that was used for the keeping or selling of controlled substance in violation of Article 7 of the Public Health Code, being MCL 333.7101, and that's contrary to MCL 333.74051D and MCL 333.7406. Count 2 is a high court misdemeanor. The maximum penalty is 2 years in jail and/or $25,000 in fine. Count 3, tampering with evidence, alleges that you did knowingly and intentionally remove, alter, conceal, destroy, or otherwise tamper with evidence to be offered in an official proceeding contrary to MCL 750.483 6A. That's a felony. The maximum penalty is 4 years and or $5,000 in fines, and a consecutive sentence may be imposed for any other conviction. There's an habitual offender fourth offense notice. It says the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about September 25th, 1996, he was convicted of the offense of armed robbery in contrary or in violation of MCL 750529 in the 30th Circuit Court for Ingham County, and that on or about September 25th, 1996, he was convicted of the offense of felony firearm in violation of MCL 750.227BA in the 30th Circuit Court for Ingham County, and that on or about June 9th, 2010, he was convicted of the offense of felony firearm in violation of MCL 750.227BA in the 30th Circuit Court for Ingham County. Therefore, the defendant is subject to enhanced penalties. That enhances the penalty to life if the primary offense has a penalty of 5 years or more, or 15 years or less if the primary offense has a penalty of less than 5 years. Do you have any questions about the charges and the maximum penalty, sir? Okay, you have the right to be represented by an attorney. Mr. Lee is representing you for your arraignment. You have the right to have an attorney represent you at all of your court appearances and if you are questioned by the police. If you can't afford to hire an attorney, you can request to have the public defender's office appointed at the expense of the public. Do you understand that right?
Yes, ma'am.
You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty, not guilty, or stand mute. You have the right to have a preliminary examination within 21 days of today's date unless you waive the timeline of 21 days or unless the court finds good cause to go beyond the 21 days. You have the right at the time of the preliminary examination to require the prosecutor establish that they have sufficient probable cause that the felonies alleged were committed in probable cause sufficient to charge you as the person who committed the felony. You're currently scheduled for a probable cause conference before Judge Michael Anthony Flores. It's going to be Thursday, February 27th at 9:30 in the morning. You have a preliminary examination before Judge Flores Thursday, March 6th at 9:30 in the morning. You should have received notice to appear for those dates.
Yeah, I got it.
Very good. You can't appear for your probable cause conference via Zoom, but you must appear in person for the exam. You understand that?
Yes, ma'am.
You have the right to
I'll
the
take-
presumption. Okay, thank you. You have the right to the presumption of innocence. You're innocent until proven guilty. You have the right to proceed to trial and require the prosecutor prove your guilt by proving each element of the charges being brought against you beyond a reasonable doubt. You can remain silent at your trial. You can subpoena witnesses that will testify on your behalf. You have the right to cross-examine in court any of the witnesses called to testify against you, and you can waive your silence and testify on your own behalf. Do you understand those rights?
Yes, ma'am.
Is he requesting court-appointed counsel, Mr. Lee?
Yes, he is, Your Honor.
What's your home address, sir?
1406 Lions Ave, Lansing, Michigan, 48910.
Are you employed?
Work Amazon.
What's your phone number?
517-894-7103.
Are you currently on probation or on parole?
No, man.
You can address the court on bond, counsel.
Thank you, Your Honor. Mr. Brown reports that in addition to the felony convictions that the court has elicited, that there was also a domestic violence conviction in 2010. He did serve prison time for the armed robbery conviction in 96 and also for the convictions in 2010. Was released from prison in 2012. Reports that he has not been charged or convicted with anything since that time. He does live here in the Lansing area and has his whole life, has a full-time job at Amazon. In addition, he has several children here in the area that he contributes to their livelihood as well. We would just ask the court to consider those things in setting bond.
You said he reported he had not been charged or convicted since when?
Since he was released from prison in 2012, Your Honor.
I have 2012 charged with possession, cocaine, heroin, other narcotic, charged with police officer assault, resisting, obstructing, charged with interfering with electronic communication device, charged with domestic violence. In 2013, I have charging with felony, interfering with electronic communications and misdemeanor assault and battery that he pled guilty to. I have another 2013 charge of domestic violence, another 2013 charge, that's a licensing charge. I have a 2015 impaired driving, pled guilty. I have another charge, a licensing charge. 2018 charge of domestic violence. 2019 charge of domestic violence. Another 2019 weapons felony third offense notice. Another weapons carrying concealed. Another felony weapons firearm possession by felon. Another felony assault with a dangerous weapon, all in 2019. 2021 domestic violence charge. Another 2021 felony interfering with communication device. Another 2021 domestic violence charge. Another 2021, looks like there was a conviction, but he was charged with 1, 2, 3, 4 counts. What felony animals abandoning cruelty, 4 to 10 animals. He ended up pleading guilty to abandoning cruelty 1. Did you forget about all of that, sir?
Oh, he asked me the ones I got convicted. That's what I told him.
Okay,
Yeah.
but you've had
I told
convictions
him-
since but you've had convictions since 2010, correct?
Yeah, for the dogs and all that. But I'm talking about when he asked me, he said, I told him what I was convicted for, not all I've been charged for.
But you've had convictions since 2010.
Yeah, but when
correct.
he asked me, I didn't remember the whole list of stuff. I was telling him the main, like my armed robbery and my gun charges and stuff.
Okay, so you forgot about the conviction that
Oh,
you had in.
No, I didn't, ma'am. I was telling him, I told him, and I told him I've been charged. I wasn't trying to hide nothing from, because I know y'all gonna have it. This ain't my first time. I just told him off the top of my head, stuff that I've been charged for. Like he asked, that's all.
Got it. Okay, let's see here. He's facing 1, 2 felonies, a high court misdemeanor, a 4th offense notice, but the primary offense is less than 5 years, so it is enhanced to 15 years or less. A bond is set in the amount of 10,000 personal recognizance with GPS tether. While on bond, you have the following conditions. You're not to possess a firearm or weapon of any kind. You're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess any alcohol or drugs. And not to travel outside the state without prior approval of the court, and you must report to pretrial services within 48 hours of your release. Do you have any questions about your bond?
Yes, ma'am. Will I be able to do Amazon?
I don't see why you wouldn't. I don't know what their conditions are about you having a charge. I gave you a
I'm
personal
talking about the teller.
that I don't know. You have to ask Amazon. Would you be able to do Amazon with the tether? I don't know what their conditions are about your employment.
Oh, it's not a house, like I gotta stay in a house teller?
I know you did not have to stay in the house.
Oh, well,
You can't
okay,
leave-
I'm good.
You can't leave you can't leave the state without prior approval of the court, but
Oh, I can do it.
you have to, you're gonna wear a tether so we can know where you are.
Okay, I can do it. I'm good. They let me do it.
All right, any additional matters for the record, counsel?
Nothing further. Thank you.
Thank you, you're all set.
Thank you.
Okay, on the record in the matter of the people of the state of Michigan versus Charel Turner, 25-00519 FY. Appearance, please.
Assistant Public Defender John Lee on behalf of Charel Demeyer Turner.
Okay, I have here a felony complaint, and the allegations are that on or about February 18th, 2025, at the area of 420 South Grand Ave, Lansing, Michigan, that you committed the act in count 1 of assault with a dangerous weapon, that being known as a felonious assault. The allegations are that you did make an assault upon a Desiree Allen with a dangerous weapon, that being a knife, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, and that this was done contrary to MCL 750.82. Count 1 is a felony, and the maximum penalty is 4 years and or $2,000 of fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There is a count 2, assault with a dangerous weapon, alleging that you made an assault or assault on battery upon a Kenneth Robertson with a dangerous weapon, that being a knife, but without intending to do great bodily harm, without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. Again, count 2 is also a felony, maximum penalty 4 years and or $2,000 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There's an habitual offender second offense notice. It says take notice that the defendant was convicted of a felony or attempt to commit a felony in that on or about November 7, 2018. He was convicted of the offense of carrying a concealed weapon in violation of MCL 750.227 in the 30th Circuit for Ingham County, state of Michigan, and therefore the defendant is subject to the enhanced penalties under MCL 769.10. Enhances the penalty to 1 1/2 times the maximum sentence on the primary offense or less term. Do you have any questions about the charges read there and the maximum penalty, sir?
No, I don't.
You have the right to be represented by counsel. If you can't afford to hire an attorney, you can make a request to have the public defender's office appointed at the expense of the public. You have the right to remain silent. Anything you say, anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue all the way to a jury trial. You are being charged with felony, so you have the right to have a preliminary examination on count 1 and count 2, and require the prosecution establish that they have sufficient probable cause that the felonies were committed, and probable cause sufficient to charge you with the felonies. Are you currently scheduled to have a probable cause conference before Judge Cynthia Ward Thursday, February 27th at 8 a.m. You have a preliminary examination before Judge Ward on Thursday, March 6th at 8:30 in the morning. You have the right to have those exams within 21 days of today's date, unless you waive the 21-day timeline or the court finds good cause to go beyond the 21 days. You understand your right, and did you get a notice to appear with those dates on it?
You said the 27th and March 6th, right?
That is correct, sir.
Oh, yes, I did.
And your probable cause conference is at 8 a.m. You can appear via Zoom for that, long as you have a video and the ability to be in a place conducive for court. And then your preliminary examination, you have to appear in person, okay?
Yeah, can I appear for both in person, possible?
You can do both in person.
Okay,
Okay, and so you have the right again to trial and the right to be presumed innocent until proven guilty. You have the right to require the prosecutor prove each element of the charge or charges being brought against you beyond a reasonable doubt. You have the right to remain silent at trial and not have that silence be used against you. You can waive your silence and take the stand at your trial and testify if you'd like. And you have the right to subpoena witnesses that will testify for you at trial and the right to see, hear, or question any witness called to testify against you. Do you have any questions about those rights?
no.
Is he requesting court-appointed counsel?
Yes, he is, Your Honor.
Are you currently on probation or on parole?
No,
Are you employed?
at the moment, no, but I did have 2 interviews last week.
What's your home address?
124 Fenton Street. Spell it Fenton.
What's your phone number?
517-455-3673.
Have you missed court in the past?
No.
You can address bond counsel.
Thank you, Your Honor. Mr. Turner reports that he has the convictions that Your Honor mentioned, for which he successfully completed probation. He also had a trespassing conviction in 2024. Reports that he has always appeared for his court dates, that he has lived here in the Lansing area his whole life and intends to participate in these proceedings.
Bond is set in the amount of 5,000 personal recognizance with GPS tether. There's a no contact order in place. You're not to have contact directly or indirectly with the following people: Desiree Allen and Kenneth Robertson. You're not to be within 1,500 feet of wherever they are. You're not to be at the address of 420 South Grand Avenue. You're not to possess a weapon or firearm of any kind. You're not to travel outside the state without prior approval of the court. You need to report to pretrial services within 48 hours of your release. You're not to use any drugs or alcohol. Do you have any questions about your bond conditions?
So exactly, how do I get the tether exactly?
You'll get that information in the jail. Any other questions?
And do I have to like pay for it?
You can apply for assistance to pay for it if you're indigent. You have any other questions?
My only question is, how much is it?
Again, there's an application for you. If you're unemployed, you're considered indigent, there's an application so that the cost can be covered, okay?
Okay, oh yeah, my only other question is, so did I ever lose the right to defend myself?
You do not lose the right to defend yourself, but that's a right that must be asserted at trial, okay?
Okay, yeah, this whole thing is just a learning experience for me, really. So I'm really
Okay.
learning a lot. So thank you. I appreciate it.
Thank you. On the record, in the matter of the people of the state of Michigan versus Timmy Fields, 25-00521. Council appearance.
Assistant Public Defender John Lee appearing on behalf of Timmy Lee Fields.
Okay, I have a 22 count complaint here. Actually, a 20 count complaint. Let's see here. I have here in count 1, a felony complaint that alleges that you committed the act of assault with intent to murder, and that on or about February 17, 2025 at 422 West Saginaw Street, Apartment 1, City of Lansing, Ingham County, that you did make an assault upon a Priscilla Riley with the intent to commit the crime of murder contrary to MCL 750.83. That's a penalty of life or any number of years. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Count 1 is a felony. Count 2, assault with a dangerous weapon, as well as count 3 is assault with a dangerous weapon. And then count 4 is assault with a dangerous weapon. Alleging that at the address of 422 West Saginaw, Apartment 1, on or about February 17th, that in count 2, you did make an assault upon Priscilla Riley using a shotgun. In count 3, it says the assault was upon a Lindell Field using a shotgun. And then count 4, it says that the assault was upon a Travion Riley using a shotgun, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. Count 2, 3, and 4 are felonies. Maximum penalty in each 4 years and or $2,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Count 5, count 6, count 7, and count 8 are all weapons, firearms possession by prohibited persons, alleging that you did possess and or use a firearm when ineligible to do so because you have been convicted of home invasion in the 2nd degree, a specified felony that is punishable by imprisonment of more than 1 year, and the requirements for regaining eligibility had not been met, and that was contrary to MCL 750.224 F6. Count 5, 6, 7, and 8 are felonies. Maximum penalty in each 5 years and or $5,000 in fines, and there's a mandatory forfeiture of the weapon or device required under the law. Count 9 is weapon ammunition possession by a prohibited person, alleging that you did on the date and time in question possess ammunition when ineligible to do so because you have been convicted of home invasion 2nd degree, a specified felony that is punishable by imprisonment of more than 1 year, and the requirements for regaining eligibility had not been met. That's a felony. Maximum penalty 5 years and or $5,000 in fines, and mandatory forfeiture of the weapon or devices required under the law. Count 10 is weapons, firearms, careless discharge, causing injury or death alleging that you did because of carelessness, recklessness, or negligence, but not willfully or wantonly cause or allow a certain firearm under your immediate control, that being a shotgun at a vehicle, shot a shotgun at a vehicle and or near a person and or peoples, to be discharged so as to kill or injure another person, that being a Lindell Latrell Fields, contrary to MCL 752.861. That is a high court misdemeanor. The maximum penalty is 2 years or $2,000 in fines. Count 11, weapons, felony firearm. Count 12, 13, 14, 15, 16, 17, 18, and 19, and 20. Actually, all are weapons, felony firearm, alleging that you did carry or have in your possession a shotgun at the time that you committed in count 11, assault with intent to murder as to one victim, and count 12, a shotgun in the time you committed assault with a dangerous weapon as to the second alleged victim. In count 13, it's assault with a dangerous weapon, felony firearm. 14 is applied to the other assault with a dangerous weapon. Count 15, felony firearm, is accompanied or applied to the weapons, firearm possession by prohibited person. And then count 16, 17, and 18 also applied to the remaining weapon, firearm possessions, each of them alleging that you had a firearm in contrary to MCL 750.227B. Each of those counts of felonies, the maximum penalty are 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. There's a mandatory forfeiture of the weapon or device in each file. And then count 19, also count 20, I don't know if I said, that are also additional weapons, felony firearm associated to the other charges that were applied. It says this notice only applies to count 1, assault with intent to murder. There's an habitual offender fourth offense notice attached to count 1. It says mandatory 25-year sentence. Take notice if defendant was previously convicted of 3 or more felonies or attempt to commit felonies, and that at least one of these crimes was a prior listed felony as defined in MCL 769.126A. It says on or about July 25th, 2007, the defendant was convicted of the offense of home invasion, 2nd degree, in violation of MCL 750.110A3 in the 30th Circuit Court for Ingham County, State of Michigan. And that on or about March 22nd, 2002, he was convicted of the offense of motor vehicles operating a chop shop in violation of MCL 750.535A2 in the 3rd Circuit Court for Wayne County, State of Michigan. And that on or about February 18th, 1997, he was convicted of the offense of stolen property, receiving and concealing in excess of $100 and contrary to MCL 750.535A in the 3rd Circuit Court for Wayne County. Therefore, the defendant is subject to the penalties provided by MCL 769.121A. The penalty, again, is life or a lesser term, but the minimum sentence must be at least 25 years. This following notice applies to all counts with exception to count 1. It's the habitual offender fourth offense notice stating take notice the defendant was previously convicted of 3 or more felonies or attempt to commit felonies. Again, in that on or about July 27, 2007, he was convicted of the offense of home invasion, 2nd degree, in violation of MCL 750.110A3 in the 30th Circuit Court. That on or about March 22nd, 2002, he was convicted of the offense of motor vehicles operating a chop shop. and that on or about February 18th, 1997, he was convicted of the offense of stolen property, receiving and concealing in excess of $100 in the Third Circuit Court for Wayne County. Therefore, the defendant is subject to the penalty of life if primary offense has a penalty of 5 years or more, 15 years or less if the primary offense has a penalty under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the charges in counts 1 through 20 and the maximum penalty as well as the habitual offense notice that was applied to each count?
Not really, yes.
Is yes or it's, I'm not asking if you understand why you were charged. I'm asking if you understand what was read. And if you don't, you can just let me know.
Yes and no, because yes, ma'am, yes, ma'am, yes, ma'am.
You have the right to be represented by an attorney. Mr. Lee is representing you today for your arraignment, but you do have the right to have an attorney that's going to represent you throughout the pendency of this criminal prosecution, and you have the right to be represented by an attorney if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the public defender's office represent you at the expense of the public. Do you understand that?
Yes, ma'am.
Is he requesting the public defender's office to represent him?
Yes, he is, Your Honor.
The court will enter a plea of not guilty on your behalf. Mr. Fields, you have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. And if you stand mute, the matter will continue all the way to a trial. You have the right to a preliminary examination within 21 days of today's date, unless you waive that 21 days or the court finds good cause to go beyond the 21 days. At the time of your exam, you have the right to require the prosecutor establish that they have sufficient probable cause that these felonies were committed, and then sufficient probable cause to charge you as the person who committed those felonies. Do you understand those rights so far?
Yes, ma'am.
You're currently scheduled for a probable cause conference before Judge Cynthia Ward, February 27th at 9 o'clock in the morning. You have a preliminary examination before Judge Ward Thursday, March 6th at 9 a.m. You must appear in person for your preliminary examination. And I see there that you do have your notice to appear in the Zoom instructions, which again, the Zoom instructions can be used for your probable cause conference, but you must appear in person for the exam. Do you have that record before you, sir?
Yes, ma'am.
Okay. You have the right to be presumed innocent until proven guilty and continue to trial. And you have the right to jury trial. You have the right to require the prosecutor prove each of the elements of each of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent and not have silence be used against you, to subpoena witnesses to trial that would testify for you, to cross-examine or question in court any of the witnesses the prosecutor calls to testify against you, and the right to waive your silence at trial and testify on your behalf. Do you have any questions about your rights at this time?
No, ma'am.
Okay, are you employed?
Yes, ma'am.
Where?
Burns Aerospace. BARNES Aerospace.
What's your home address?
422 West Saginaw, Apartment 1, but my plans is not to go there until this case clear. I'm moving with my brother, Jermaine Noel. His address is 1319 Barclay Drive, 48910. Phone number 313-293-2714.
That's your phone number or your brother's phone number?
My brother's.
What's your phone number? Why are people talking on my record? What's your phone number?
517-574-8676.
Are you currently on probation or on parole?
No, ma'am.
Okay, Mr. Lee, you can address bond.
Thank you, Your Honor. We would simply ask that the court consider that Mr. Fields turned himself in and intends to participate in these proceedings. He has lived here in the Lansing area for 23 years and, as reported to the court, has a full-time job that he will return to if he is able to post bond.
He turned himself in on what?
He told me that he turned himself in on the warrant for the charges that he is being arraigned on today.
That's interesting because I signed the warrant after he was in custody.
Okay. That's the best
No,
information.
I didn't. I don't know nothing about that.
Okay,
I didn't.
yeah.
I was incarcerated. I was in jail already. I don't know how that happened.
Okay, yeah, our records reflect that you were taken into custody and it was after that that the charges were stopped.
Yes.
These are serious allegations. The 20-count complaint, count one, facing life or any number of terms, but there is an habitual offender, a notice that makes the minimum a sentence of 25 years in jail or in prison if convicted. There are a number of weapons. Well, actually, each of these counts, the 20 counts, involve the use or allegations of a weapon, that being a shotgun. I don't know why you keep trying to talk over me.
I'm sorry. I'm so sorry. I'm nervous and I'm shocked. I'm real shocked.
I'd be nervous. I'd be nervous too, but that doesn't mean you can talk over me while I'm creating a record.
Yes, ma'am.
There are allegations of a shotgun, and allegation of attempt to murder at least one individual and felonious assault others. And these allegations are serious. So personal recognizance bond is not appropriate. Bond will be set in the amount of 50,000 cash surety with GPS tether.
Oh man.
While out on bond, you're not to have contact directly or indirectly with a Priscilla Riley or a Lindell Fields or a Travion Riley. You're not to be at the address where they live, work, or go to school. You're not to be within 1,500 feet of wherever they live, work, or go to school. Do you understand that?
Yes, I do understand that, ma'am. Hey, can I please say something, please?
Yeah, but I'm going to remind you again. Let me remind you first of your right to remain silent, because anything you say can be used against you. This is a recorded proceeding, so the prosecutor does have access to everything that you say, but you can say what you need to say.
Yes, ma'am. That's my wife and kids. Why would I do that? I don't understand.
Please don't make any comments about the case. Nothing at all about the case. You're pleading not guilty. Please exercise your right to remain silent.
Yes, sir.
Okay. Also, while out on bond, again, there's GPS tether with 1,500 feet and victim notification. You're not to possess a firearm ammunition, or weapon of any kind. You're not to travel outside the state without prior approval of the court. You're not to engage in any assaultive or threatening behavior. You're not to use any drugs or alcohol unless you have a valid prescription. You're not, and you must report to pretrial services within 48 hours of your release from custody. Do you have any questions about your bond conditions?
Um, um, uh, how can I get that lower? Cause I don't have money like that.
Oh, that's not how this works.
Okay. Man. Okay, thank you. That's it.
Okay, yep, you need to get a bondsman, sir.
Okay.
Any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
Okay, you're all set. It must be Angela Scott.
Yeah.
Are you okay?
Yeah.
You don't look
Yeah.
like you're okay.
Okay.
Step forward. You're under the influence of something?
Oh,
When's the last time you were under the influence of something?
yesterday at 11 o'clock in the morning.
She does not appear to me to be well. Mr. Lee, did you speak to her?
I did, Your Honor. However, parts of the interview, she was silent as she did not appear to be doing well to me either, and may in fact need medical attention.
I agree. I'm going to remand her to have some a further medical evaluation before I proceed with an arraignment. I don't know if she's in the right mindset for any. proceeding. I'm sorry.
I am in the right mindset. I want to go home.
Just because you got arraigned doesn't mean you're going home.
No, but I want to go home. I'm not intoxicated or anything like that. I just
What's
woke
today's
up.
date? What's today's date, ma'am?
19th.
Of what?
February.
Okay, I have a complaint here. The allegations are that on or about, and it's a felony complaint. On or about April 10th, 2024, in the area at or near the area at or near 605 South Foster Ave, City of Lansing, Ingham County, State of Michigan, that you did allegedly in count one, commit the act of controlled substance, possession of cocaine, heroin, or other narcotic less than 25 grams. The allegations are that you did knowingly or intentionally possess less than 25 grams of the mixture containing a controlled substance, fentanyl, and that this was contrary to Michigan Compiled Law 333.74032A-B. That's a felony. The maximum penalty is 4 years and or $25,000 in fines. It appears to me she's going through a withdrawal.
Yes, I am.
Okay. Yeah. Right to be represented by an attorney because this is a felony that you're being charged with. You have the right to have an attorney represent you at all of your court dates, and you have the right to be represented by counsel if you are questioned by law enforcement. You understand that, right? Okay, because this is a felony, you have the right to preliminary examination within 21 days of the date that you're arraigned, which is today. You are scheduled for preliminary examination. That's before Judge Michael Anthony Flores. It's going to be March 6th at 9 a.m. in person at the court. You have a probable cause conference that's scheduled before Judge Flores February 27th at 9 a.m. You must appear in person, okay?
Yeah, can I get a PR bond? I turned myself in.
Can you do what?
PR bond, I did turn myself in.
Did I ask you to address bond right now, or did I ask you about your court? I asked you about your court dates, correct?
Yes.
Okay. You got your notice to appear for Judge Ward? I'm sorry, for Judge Flores? Okay, and you must appear in person, okay?
Okay.
Okay. You have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue all the way to a jury trial. You have the right to be presumed innocent until proven guilty and require the prosecution prove your guilt at trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent and not have silence be used against you. You can waive your silence and testify at your trial if you'd like. You have the right to subpoena witnesses that would testify or present defenses on your behalf. And you have the right to see, hear, or question any other witnesses that the prosecution calls to testify against you. Do you have any questions about that, ma'am?
Oh.
Are you currently on probation?
No.
Are you on parole? I didn't hear your response.
No.
Okay. What's your home address?
30 South Haysford, Lansing, Michigan, 48912.
What's your phone number?
517-816-1114.
What was the numbers for your address?
430.
430. Are you employed?
Oh.
She requested court-appointed counsel.
Yes, she is, Your Honor.
Or enter a plea of not guilty on your behalf. Counsel, you can address bond.
Thank you, Your Honor. Ms. Scott was not feeling well enough to report her prior criminal history. I did have a chance to run her iChat. However, the information there was incomplete. There were several listings of contact, but no charging and or disposition. So I can't really speak to any of her criminal history. What I can say is she reported that she worked here in the, she has lived here rather in the Lansing area her whole life and intends to participate in these proceedings. She is currently on bond for misdemeanor cases out of 54A.
How did you get in custody today, ma'am?
I didn't turn myself in.
Came in because you knew you had a warrant. How did you find out you had a warrant?
I looked online.
You said what?
I looked online.
She has a matter at what court, Mr. Lee?
54A, Your Honor. I believe it's dog license cases in front of Judge Flores.
She appeared. What, she appeared yesterday? It's interesting because if she had a pretrial before Judge Flores yesterday, then I don't understand why she wasn't told that she had a warrant.
I wasn't.
My understand, well, I'm not going to say anything.
Mr. Lee, aren't you the public defender for for Judge Flores?
I am one of them, Your Honor. My understanding is that Ms. Scott appeared at her pretrial conference yesterday and was advised that she had warrants. Whether she knew that or not prior to the pretrial conferences, I don't know. But my understanding is that she was taken into custody at that time.
Okay, so she appeared for court and that's when she was taken into custody, not that she turned herself in.
I had a warrant. I'm here, I had a warrant.
I'm sorry? I didn't understand what you're saying.
Warrant.
You knew you had a warrant?
Yes, I didn't go to court anyway.
Okay, yeah, I was just trying to ascertain your ability to get yourself to court. It looks like she came to court yesterday on her own. So I don't have a record that reflects that she does not appear in court. I do think she needs some medical attention, but I am going to grant the request for personal recognizance bond because this is from 2024, the allegations, and I don't see where she's failed to appear on this other than a summons, which I don't think that the summons went to the correct address. In addition to that, she appeared to court. So you need to continue to come to all your court dates, okay? Unless you want your bond to be revoked, okay? Bond is set in the amount of $3,000 personal recognizance. While out on bond, I am going to order that you participate in regular testing for drugs.
Okay.
You're not to engage in any assaultive or threatening behavior. You're not to use any drugs or alcohol without a valid prescription. You need to report to pretrial services within 48 hours of your release. You're not to travel outside the state without prior approval of the court. Do you have any questions for the court at this time? No questions, ma'am? I can't hear her. I'm assuming she's saying no.
Oh.
Okay, she's all set. That's all I have.
Your Honor.
Thank you, Your Honor.
We do have Harvey Edwards here now. He agreed to be seen on the trespassing charge. The other charges are not going to be issued at this time.
You agree to be seen. I don't know, you need to agree for, you need to be, agree to be seen for us to charge. I don't have to file anymore.
Is this something that we're gonna have go tomorrow then?
Correct.
Okay, thank you.
You're welcome.